You also want to talk to the client about the bond amount. At a temporary restraining order hearing, there is no statutory requirement for a bond, but there is one at the preliminary injunction hearing. And even though there's no requirement that the court order a bond at the temporary restraining order hearing, the court has the authority to do so. And I've seen courts order very, very high bonds at the temporary restraining order proceeding when I've been dealing with situations. For instance, if you're going in and your client says, well, I should have writing credit on a movie, and the producer says, in order to, if I have to change these credits, it's going to cost me $200,000, and the court orders a bond to cover all the damages that will be suffered by the responding party, plus all the attorney's fees that will be incurred potentially in removing the bond plus interest. So you need to let the client know not only may the client might be required to post a bond, but you've got to let the client know what that means is that if you later lose at the end of the case, and that restraining order and that preliminary injunction were found to be not have been correct, and you don't get your permanent injunction, that bond is available for the responding party to collect against for all the responding party's attorney's fees and any damages. And of course what will happen is if the responding party collects against the bond, which is put up by some surety, you can bet the surety is going to go against your client. So the client has to understand this temporary restraining order preliminary injunction is not something that they do with absolutely no risk. And then the third thing they need to understand on the bond is the fact that if it's a significant bond, the bonding company is probably going to require a cash equivalent collateral. You know, bonding companies don't want to be stiffed either, and so your client may not even have the financial statement to put up the bond. And it would be a shame for you to spend all that money on the expedited papers and then find out that your client can't afford the cost of the bond. The third thing that I like to discuss with my client is, do you really need a temporary restraining order, or could something else suffice? The first thing that you can think about is a temporary restraining order is only going to be of short duration, and the court, in order to grant it, is going to want to see why you need this emergency order. Now, in the example that we've got in the papers before you, this solar film was going to be put up in a matter of a couple of days, and so the client needed to get relief right away. But let's say that the client had gotten 30 days notice that this solar film was going to go up. Then the client, instead of going in on a TRO, because the client couldn't show the court why this needed to be decided in 10 days, could have gone in simply on a preliminary injunction and asked the court to set an order to show cause or a preliminary injunction. Now, you also, if you're in a lawsuit already, can even serve a notice motion for preliminary injunction, which is just the same as any other motion you would file in a proceeding. Or you could personally serve a notice of motion if you're going against the parties to the lawsuit. An order to show cause, though, has to be used if you're trying to have parties who are not parties to the lawsuit restrained. But you really need to think about, do you need that temporary restraining order, or can you just go with the more leisurely and better prepared pace of a hearing on a preliminary injunction?
No, let me interrupt and ask a question. This is a legitimate question on my part. I'm not trying to bait. I know of no instance where I can enjoin someone who isn't a party to the lawsuit. And so I think what Diane means there is someone who hasn't been served. Because if somebody's not named as a defendant or brought in as a Doe defendant later, I have taken the position, and nobody's ever shown me any authority to the contrary, that I have no jurisdiction over that person to issue an injunction.
I actually believe that you can enjoin persons acting in concert, agents, employees, just in the broader category of enjoining those individuals and requiring that notice be given to them under the case law, whereas if a person acting in concert, if they were not named in a lawsuit, you could not do by a notice motion proceeding, I believe.
Okay. I just for your own information, I would suggest if this ever becomes an issue to research it, because while it's standard in language in it, both a TRO and a preliminary injunction, that not only the defendant but his agent, employees, and those acting in concert with him are similarly enjoined and restrained, I think you're going to have a hard time finding a judge issuing an injunction against an identified person who is not made a party to the lawsuit.
In any event, when you're talking about do you want to go in on a temporary restraining order or can you wait and have just a hearing on the preliminary injunction, it's something that you need to give thought to, because obviously it gives you a little more time to fully prepare the papers for a preliminary injunction than to run in 2 days' time probably with your papers on the temporary restraining order. Now, the other thing you want to talk to the client about, though, when making that decision, remember that we've just heard earlier that a mandatory injunction is automatically stayed on appeal, but a prohibitory injunction is not automatically stayed on appeal. If you have a situation where something's going to occur and you can go in at one stage and you're going to get a prohibitory injunction, but if you wait till later and you're going to need a mandatory injunction, you know you want to go in faster. Just as an example, in the solar film case, if you go in before the solar film goes up, you're asking for an order from the court that this party be restrained from putting up the film. So you're just saying that's going to be a prohibitory injunction. But once the solar film's up, remember you're asking for a mandatory injunction. You're saying take it down. And that, of course, would be stayed on appeal. So don't just wait on the theory that you can go in and necessarily get the same relief, because the nature of the injunctive order you need may change. Also, consider the advisability of a demand letter. Particularly in dealing in trademark litigation, I have found some trade secret litigation, and just in any case, you need to give some thought to it. You may find that a demand letter will be reviewed by a lawyer who's going to write back and say, we'll stop doing it. Or they may make some kind of a proposal for stopping doing it, and it would be a shame to get into court and find out they're offering a stipulation there after you've prepared all your papers, which you could have gotten earlier. Okay, after you go through, you're going to want to meet with the client and go over all the facts and start gathering your evidence, and now you're getting ready to prepare your papers. What you want to do in terms of statutes, etc., to review, and by the way, my part of the program materials start at page 3 of the outline, and they're pretty well covered. So you want to first look at CCP sections 525 through 535. You want to look at the California Rules of Court, at the Rules of the Superior Court for LA County, Rule 801, and at the Law Department Policy Manual, sections 471 through 494. And those are all of the areas that are going to deal with the papers and that you're going to want, and the specific statutes that talk, or specific sections that talk about injunctions. Then you want to figure out what theories are you going to put forward. Is it a nuisance theory? Are you trying to restrain a foreclosure? Is it a trade secret case, etc.? And then you want to go research the specific case law and statutory law in those areas as well. You want to then consider jurisdiction. Obviously, on subject matter, any injunction proceeding you want to bring, you bring in the Superior Court if it's going to be part of the permanent relief you're seeking. Only the Superior Court can grant permanent injunctions. And even if you have $3,000 in damages plus an injunction, you're going to go into Superior Court. If you want just a provisional injunction sometime during the case, you can get those in municipal court. And in terms of jurisdiction on subject matter, you also want to consider, do you want to be in the federal court or in the state court? At the end of our presentation, Peter is going to talk in more detail about the differences between federal and state court. But keep in mind that there are significant differences, and you should consider, is this a case that can be brought in one or the other, or is it a case that even if you bring it in one, it's going to get either removed or remanded to the other? Also, on venue, you want to make certain that you choose the correct venue. Very often the client walks in the door, we practice in LA County or whatever county we practice in, the client lives there, but the defendant resides in a different county, in San Diego County, and there's not proper venue. Now, if you run into court in LA County and a change of venue motion is filed, the change of venue motion will most likely be heard, especially if there's discovery that is filed at the same time as the hearing on the injunction, on the preliminary injunction. One thing you don't want to be doing is wasting your precious time and effort in preparing a response to a venue hearing, and then there's always the danger that if it turns out that the court absolutely has no either personal jurisdiction or there's a venue problem, that you end up not having the court able to give relief. Judge Vogel, in the event that there was a change of venue motion, how would you handle that if you felt venue was properly in San Diego County, but that there should also be a restraining order issued?
The fact that it's just the wrong court would not stop me from issuing a temporary restraining order if I felt the party seeking it would suffer irreparable injury in the time it took to get to the other county and file another action. I would make an order that would remain in effect while the case was transferred, or at least the motion was heard on the change of venue issue. Oftentimes,